Good morning, everyone. This is Dr. Claire Broughton, and today I'll be discussing with you Chapter 2, Elements of Crime for Criminal Law. Let me share my screen. So as I mentioned, today we will be talking about the elements of crime. It's important for you to know about the elements of crime because without a specific element, it could be a completely different crime. Okay, I'll give you an example later. So when we talk about elements of crime, think about the periodic table of elements in chemistry, right? Each chemical, each compound, each material is composed of elements. For example, water is composed of two molecules of hydrogen and one molecule of oxygen. Also similar would be grammar and sentence construction in the English language. Again, another example would be home ingredients, okay? Ingredients of a recipe. For example, if you want to cook spaghetti bolognese, then you need to put you need to have tomato sauce. Oh, marinara. You need to have tomato sauce and spaghetti. Now, if you add another ingredient meatballs, it becomes no longer marinara, but it becomes spaghetti with meatballs. So it's the same way with crimes. For each crime, there are elements similar to ingredients that compose that particular crime. If you add another element to that particular crime, it could be a completely different crime. For example, the offense of theft. The elements of theft are intent to appropriate the property of another, okay? Intent to appropriate the property of another, okay? Now, if you add violence or intimidation against persons, it's no longer theft, but it transforms into robbery. Now, in criminal law, each element must exist beyond reasonable doubt. For example, in burglary, you have common law definition of burglary is that it's breaking and entering into a private dwelling at night to commit theft or felony. So there are several elements. Nighttime, it has to be a private dwelling. Your intent to break and enter should be to commit theft or felony inside. If it's not nighttime, for example, under common law, it wouldn't be burglary. If you didn't target a private dwelling, if that's not your target in burglary, you wouldn't be liable for common law crime. So the absence of one element negates the existence of that particular crime. That's why it's so important for you to know the different definitions of crime, different elements of crime. Now, the basic elements of a crime are actus reus, which is the conduct. The conduct can be it can be an act, omission, or it can be a failure to act. Now, a culpable mental state is the mens rea. The mens rea can be intentional, it can be knowing, it can be reckless, or it can be negligent. I will define and go over all of these levels of mens rea later in my lecture. Now you will note the plus sign. So it means that the conduct and the culpable mental state must concur. They must join together, okay? You can't have one without the other in order to cause the harm. So this is all the basic elements of a crime. Now let's look at the first element, conduct, which is actus reus. There has to be a guilty act, okay? Status cannot be criminalized because it would be against the Eighth Amendment cruel and unusual punishment clause. In fact, in Robinson versus California, the US Supreme Court struck down a California statute criminalizing being addicted to narcotics. So you'll see that being addicted to narcotics is a status. You cannot criminalize that. In another case, Papa Cristo versus City of Jacksonville, Florida, the United States Supreme Court struck down a Florida vagrancy statute because of vagueness. So the vagrancy ordinance criminalized homelessness, people living on the streets fortune teller, and being a prostitute. So the court said you can't criminalize status. Another aspect of conduct is that it should be voluntary, meaning you should have done it of your own volition, of your own free will. And this is because of the fact that our criminal law is premised on the rational choice theory. So rational choice theory presumes that you voluntarily engage in your actions, and because you voluntarily engage in conduct, then you should be punished, okay? Now, under the Texas Penal Code, Section 6.01a, a person commits an offense only if he voluntarily engages in conduct. So according to case law, the voluntariness refers to conduct and not the result. So even if the result, the end product of your actions is accidental, you may still be liable for your conduct if what you did was voluntary. I'll give you a case in point. Let's say you point a gun at Paul intending to kill him. The bullet misses the target, ricochets, and hits Peter. Are you liable for the murder of Peter? Look, you intentionally pointed a gun at Paul, right? So your action, your conduct was voluntary. Even if the result, you killing and hitting Peter, even if that result is accidental, you're still liable for the murder of Peter because you voluntarily and intentionally pointed a gun at Paul. Now let's look at Rogers versus State. According to this case, the court said voluntariness refers to one's own physical body movements. So non-voluntary acts include non-volitional acts resulting from someone else's acts. So if someone coerced you to act, you were forced, you were intimidated, then it's not volitional, it's not voluntary. Another example would be acts set in motion by independent non-human force. For example, force majeure, catastrophes, calamities, a typhoon, okay, a lightning, that would that cause you to do something, then it would be, your actions would not be voluntary. Physical reflex or convulsion, for example, epilepsy or seizures, okay? If because of an epilepsy or seizure, it caused you to have an episode while driving a car and you hit another car because of epilepsy, you may not be liable if you didn't know that you had epilepsy, okay? And you didn't take any medication while driving. It's a product, if your action was a product of unconsciousness, hypnosis, or other non-volitional impetus, then your actions are not voluntary. Now let's look at this case. During the Korean War, a mother dreamed an enemy soldier was on top of her daughter. In her sleep, she got up, walked to a shed, got an axe, went to her daughter's room, and plunged the axe into her, believing she was killing the enemy soldier. The daughter died instantly, and the mother was beside herself with grief. Is the mother criminally liable for the daughter's death? Why? Here, she's probably not liable, most likely not, because she was asleep, okay? She was sleepwalking, so her actions were not voluntary. Another example, Dan is a student suffering from epilepsy. While attending his criminal law class, he suffers a seizure. During the incident, his right arm and fist strike out and hit his seatmate Paul in the face, giving Paul a black eye. Is Dan criminally liable for Paul's black eye? Why? Dan would not be criminally liable because his actions, his conduct was not voluntary. He was suffering a seizure when he assaulted Paul. So under Texas law, voluntary conduct can be classified in three forms. First, acts. There has to be overt action out that is visible in the outside world. Omissions to act, which is failure to act, and possession. Now let's look at the first, voluntary conduct or actions. So an act is a bodily movement, whether voluntary or involuntary, and it also includes speech. Now, evil thoughts, what you think, no matter how hateful, no matter how vile, is not punishable. Written or oral communication is also punishable. Let's look at this example. Wishes. Dina tells Paul, her ex-boyfriend, I hope you die, die, die. No offense, because here's just a wish, right? Dina then tells Paul, I'm going to cut your guts out right now with this cleaver. Now here, it would be assault by threat, okay, because I already threatened Paul. Dina tells Pam, you better stay away from Paul or else. Is this a threat? What do you think? Is the or else, does it rise to the level of a threat of bodily injury? Now, the Dallas City Ordinance prohibits sleeping in a public place. Okay, so if you sleep or doze in a street, alley, park, or other public place or vacant lot adjoining a public street or highway, you would be criminalized under the Dallas City Ordinance. Now, what if Dan dozes off due to a sudden attack of epilepsy? Again, ask yourself, is this voluntary? The second conduct is omissions to act or failure to act. There are three instances under the Texas Penal Code wherein you would be liable for your failure to act. First, if you initiated a harmful condition that required you to act. For example, if you failed to render assistance to your victim in a motorcycle or motor vehicle accident. Second, if you possess an explicit, okay, clear legal responsibility to act under certain circumstances. For example, you fail to pay child support, you fail to pay taxes, you would be liable because you have a duty to do so. Third, social harm in failing to act far outweighs any potential risk to the individual. For example, failure to report a suspected act of child abuse, failure to report a felony, or failure to report the location of a dead body. Now, let's look at the first example of failure to act wherein you are liable. When you, the defendant, okay, instigate the harm. Let's look at this case. Dan, while driving from work, comes upon an accident involving a school bus and train. The bus is on fire and young children are trapped inside. Dan, a healthy 30-year-old male, decides not to rescue the children. Is he criminally liable for his failure to act? What do you think? In the first case, he didn't initiate the harm, right? He just came upon them. So he is not liable for his failure to act. He is morally obliged, but no legal liability, so he cannot be criminalized. Second case, Dan, in a drunken stupor, drives his car and rams a school bus, causing it to swerve off the road and into a nearby ditch. The bus catches fire. Is Dan criminally liable for his failure to act? Yes, in this case, Dan was the one who initiated the harm because he rammed the school bus. Since he caused the harm, then he would be liable for failure to rescue the children in that school bus. Third, legal duty to act. Second case of failure to act. If you have a legal duty to act, let's look at these cases. First, Dieter is a convicted sex offender. He does not register his address with a local law enforcement authority. Is he criminally liable for his failure to act? Yes, because there are sex offender registration laws that require him to register. Second, Dan is walking along the beach. He sees Paul swimming in the ocean, having difficulty swimming against the strong current that is dragging him away from shore. He ignores his pleas even though he is an experienced swimmer. Is he criminally liable for his failure to act? What do you think? Does he have a legal duty to act? No, he doesn't, right? He didn't initiate the harm. He's not a lifeguard. He may be morally obliged to save Paul, but he's under no legal obligation to do so. Now, possession. Aside from actions and omissions, you're liable for possession of certain materials. You should note that under the property law, there's both actual or constructive possession. Actual possession means that you have physical possession of the object. Okay, it's under your dominion. You have full ownership, you have full control of that property. Constructive possession arises when you do not have physical possession of the property, but you have control or symbolic possession over it. For example, the keys to your car. Even if your car is parked in the parking lot, you have the keys with you, you have constructive possession of that car. Okay. Some items are considered, possession is considered illegal if you possess these contraband items. And you don't pay taxes to the government. In the 1800s, if you possessed opium and marijuana, you'd be liable. Gangster paraphernalia such as submachine guns and sawed-off shotguns. In the 1970s, if you possess endangered species, then you would be criminally liable under the CITES, which is the Convention on International Trade of Endangered Species. So if you possess elephant tusks, python skin, bald eagle feathers, all endangered species, if you didn't pay any taxes on it, then you'd be violating import and export regulations. Knowing possession means that you, the possessor, must be aware of the nature of the object possessed. If you were unaware, then you're not liable, criminally liable for possession of contraband items. Let's look at these cases. First case, Dan buys a bag of cocaine from his dealer. Is he liable for possession? Yes, definitely, because he knows about the contents of that bag. Case number 2, Dan buys cocaine from his dealer and sends it to his brother Paul by FedEx. Is the FedEx delivery guy liable for possession? Probably, well, most likely not, because the FedEx delivery guy did not have knowledge of the contents. So as I mentioned, there are two forms of possession. First, actual possession, wherein you have direct care, custody, control, and management over the item, and constructive possession, wherein you have dominion and control over the object without the item being in your actual presence. Now, let's look at constructive possession. This will illustrate what I mean by constructive possession. Dan, a drug dealer, sells cocaine to Dennis. The cocaine is in Dan's locker in a nearby building. Dan gives Dennis the keys to the locker. Is Dennis liable for possession of cocaine? What do you think? Yes, because Dennis has constructive possession of the cocaine since he has the keys to the locker. The keys is constructive possession. It's symbolic of control over the bag of cocaine. Now, this is a little bit a concept that is a little bit difficult to grasp. Okay, attendant circumstances. So aside from your actions and the result, there are certain conditions attached to your actions that make your actions criminal. Okay, so attendant circumstances occur with your actions and change the nature of your act. They are conditions. Okay, conditions surrounding your action. I'll give you an example. Dan is drinking and driving his car in his private estate, Black Acre. He's not criminally liable for DWI, right? If he exits his private estate and drives on a public highway, then he becomes a DWI offender. So here, you will see that the public highway is an attendant circumstance. It's a condition attached to your action, which changes the nature of your action from non-criminal to criminal. So there are several attendant circumstances or conditions, quality that affect your actions. These are who, what, where, when, and how. So let's look at the first attendant circumstance. Who? Under Texas criminal law, acts are criminal if done by certain persons. Okay. So let's look at this example. Dan gives his brother $1 not to tell their mother that he smokes marijuana. Is Dan liable for bribery? No, since bribery requires that one of the parties is a government official. Here, his brother is not a government official. Another example would be if particular persons are the victim. So it would be sexual assault if the victim is under 17 years old. Another attendant circumstance is where. So where refers to the location of the act. If your act occurred in certain places, it would be criminal. Let's look at this case. Dina walks around naked in the privacy of her dorm room. She is not liable for indecent exposure. If she walks out of her room and strolls to her campus, she may be criminally liable, right? So here you have public place, the location of the act, that transforms her action from non-criminal to criminal. Again, another example would be destruction of property in Indian reservations. It would be federal criminal law since Indian reservations are federal property. Now, the third attendant circumstance is why. So why refers to the reason behind your actions, okay? It's the motive for crime. I'll give you several examples. First, Dan shoots and kills his professor, Paul, because Dan gave Paul gave Dan an F in his criminal law course. Dan, in this first case, will be prosecuted for murder. Second case, Dennis shoots Paul, the professor, because Dan hired him to do so. Dennis will be prosecuted for capital murder. So here, the payment by Dan to Dennis qualifies and changes the crime from simple murder to capital murder. Third case, Dennis strikes Peter with his fist. Simple assault. Okay, but if Dennis strikes Peter because Peter is a witness in Dennis's trial for murder, Texas will enhance Dennis' punishment. So you see how your reason for a crime, your reason for your conduct changes the crime. It changes the penalty. The fourth attendant circumstance is how. How refers to the manner the crime was committed. For example, if you committed homicide or murder through poisoning, death penalty would be an option. Now, if you committed homicide through use of a firearm or other deadly weapon such as a chainsaw, you are not eligible for probated or reduced sentence. Now, let's look at culpable mental state or mens rea. There's a Latin maxim by Sir Edward Coke, who was an English jurist, and the Latin maxim goes, actus non facit reum nisi mens sit rea, meaning an act does not make someone a criminal unless their mind is guilty. So there has to be a guilty mind or a culpable mental state. This is based on the theory of deterrence or free will, wherein it presupposes that men are rational beings. So criminal law is aimed to prevent them from engaging in criminal behavior because they weigh the costs and benefits of an action. Now let's look at mens rea. Let's say you are driving within the speed limit and operating your car cautiously. The weather suddenly turns bad and heavy rain batters your windshield, preventing you from seeing clearly. As you approach the intersection of 11th Street and Sam Houston Avenue, a speeding car from your left cuts through the intersection. You strike the car, causing damage and injuring the driver. Are you criminally liable? What do you think? No, in this case, you don't have the culpable mental state because of the weather. So it's not voluntary, right? It was caused by force majeure. Now, under the Texas Penal Code, there are 4 levels of mens rea. First, intentional. Second, knowing. Third, reckless. And fourth, criminal negligence. Please watch the video in Module 2 on mens rea, on the levels of mens rea. Now, under the Texas Penal Code, blameworthiness can refer to your conduct, okay? It can refer to the results of your conduct, or it can refer to the circumstances surrounding your conduct, such as attendance circumstance. Some crimes can also involve 2 different mens rea. It can refer to the nature and the result of the conduct. For example, robbery. You must have intent to obtain control of the property, and you must also have the intent to cause bodily injury to another. Now, let's look at the first type of mens rea, intentional. So, general intent means that the actor purposely engaged in the conduct. So he committed his actions on purpose. Specific intent means that the actor has a specific goal in committing the act. For example, burglary, okay? Burglary under the Texas Penal Code means breaking and entering into the dwelling of another for the purpose of committing theft or felony inside. So here you have 2 types of intent. General intent to break and enter, and you must have specific intent, okay, a goal once inside to commit theft or felony. Okay. So intentional as a mens rea can refer to your conduct. It can refer to the result of your conduct, and that's it. Okay. So what I mean by it can refer to the conduct? So let's say Dan threatens Paul with bodily injury. This would be assault. Okay. So because he intended his action, the threats. Now, if Paul is afraid of Dan because of Dan's erratic behavior, Dan has not committed any assault since he has not intentionally threatened him. Okay, so here, this particular case shows that Dan has not done anything. His actions were not intentional, okay? So he would not be liable for assault. Intent can also refer to the result of the actor's conduct. Let's say Dan shoots Paul, intending to kill Paul. However, the bullet misses Paul and ricochets and hits Peter, okay? So here, Dan intended to kill Paul, okay? The mere fact that he killed someone else, Peter, would not absolve him from the crime. The second level of mens rea is knowing. This means that the offender is aware of his conduct or his actions, and that his actions would reasonably be certain to cause the result. So he's sure, okay? He's sure that once he acts, a certain result or a certain harm would come about. This case would illustrate what knowing means. So Fred accidentally strikes Ricky with his car. Fred stops and finds out that Ricky is alive but needs to be taken to the doctor. Fred fears that he will be arrested and flees the scene. Ricky dies lying by the side of the highway. Fred did not intend to kill Ricky here, but was aware that Ricky would die without medical attention. So knowing, you know that by leaving him at the side of the road is reasonably certain that he would die. So knowing, you didn't intend to that he dies, but you knew he would die. So under the Texas Penal Code, knowing, the mens rea of knowing refers to either the conduct, the result of the conduct, or the circumstances surrounding the conduct. Okay, so I will leave you to read this. Now let's look at recklessness. Let's look at this case. You are late for your midterms in CJ, criminal law. Now you drive to your criminal justice building at 60 miles per hour on a 35 miles per hour zone. You approach a four-way stop sign, making a rolling stop, and as you continue, a car approaches from your left. You hit the car and kill the driver. Are you liable? Was it reckless for you to speed at 60 miles an hour on a 35 miles per hour zone? And was it reckless of you to make a rolling stop, okay, on a four-way stop sign at an intersection? So recklessness means that you are aware of a risk that something would happen, something bad would happen, and you consciously disregard it. So that's what recklessness means. You know that there's a risk. You're aware, full knowledge. So the risk must be substantial and unjustified. And recklessness means that you grossly deviated from the standard of care that an ordinary person would exercise under the same circumstances. So the criteria, the standard is, what would an ordinary person do, okay, under the same circumstances? What would an average person do? Okay, how would an average person act like? So the average person would have an average degree of care. So if you deviated from what an average person would have done, okay, to exercise care in that person, and your deviation was gross, it was substantial, then you are reckless. Okay. Under the Texas Penal Code, recklessness refers to either the result of the conduct or the circumstances surrounding the conduct. As I mentioned, the risk must be substantial and unjustified, and there was gross deviation from the standard of care that an ordinary person would exercise under the same circumstances. Now, sometimes violation of another criminal statute while committing the offense is often considered as proof of recklessness. For example, Dan owns and operates a chicken processing facility. To speed up production, he disregards work and safety regulations. One day, Paul, his employee, is seriously injured because a safety device on a saw was removed to make slicing faster. Is Dan liable? Okay. Okay, what here can be used as proof of Dan's recklessness? Here, Dan would be liable. He was reckless, okay, because he grossly deviated from the standard of care that an ordinary person would exercise under the same circumstances. What could be used as proof? Well, he disregarded work and health and safety regulations. He violated another criminal statute while committing the offense, so it could be used as proof of recklessness. Now, let's look at criminal negligence. Criminal negligence under civil law is composed of 4 elements. First, you have a duty. Second, you breach that duty. Third, Because of the breach, there's causation, it caused damages. The standard of care in civil lawsuits are what would an ordinary person have done in similar circumstances. If you deviated or you did not follow what an ordinary person would have done, then you are negligent. However, in criminal law, criminal negligence requires substantial deviation from an ordinary standard of care. So it's not just, normal deviation, but it has to be substantial. Let's look at criminal negligence that refers to the result of the conduct. Dina is putting on makeup while driving. She accidentally hits and kills a pedestrian. Is she liable? Did she deviate? Was there substantial deviation from the ordinary standard of care that another person would have exercised while driving? Would you have driven while or would you have put on makeup? For females out there, would you put on makeup while driving? Would an average person put on makeup while driving? If not, then Dina is negligent. The second case refers to negligence regarding the circumstances surrounding the conduct. So harboring a runaway child would be considered negligent. Some crimes require criminal liability regardless of negligence. These are strict liability or malum prohibitum offenses. So examples would be products liability, okay, defective goods, air and water pollution standards, sale of alcoholic beverages, and traffic laws. If you speed, there's strict liability. Okay. Now, sometimes mistake may negate intent. For example, Dan goes to dinner at a chic restaurant. He leaves his red sports car with the valet to be parked. Upon concluding his meal, Dan hands the valet his claim ticket, and in a few minutes, the valet produces a red sports car. On his way home, Dan finds out that the car is not his, but another of the same model. Is he liable? Was there intent? Okay. No, there was no intent. It was just mistake. Same as above, but Dan keeps the car away anyway since it has lower mileage. Would he be liable? Think about it. Think about what I lectured so far. Concurrence. The actus reus must concur with the mens rea. It has to occur at the same time, okay? Let's look at this case. Dan, angry at his CJ 264 criminal law professor, Paul, decides to kill him. He plans to buy a pistol and shoot Paul. As he drives to the store, Dan's car accidentally strikes Paul. When Paul crosses the street before the walk don't walk sign changes in his favor, Paul dies. Is he liable for murder or manslaughter? Probably in this case, no, right? Because although he had the criminal intent, the mens rea, to kill Paul, at the time that he caused the death of Paul, he didn't have the mens rea. Okay? He was driving the car and it was an accident because Paul crossed the street before it was his turn to cross the street. So there was no concurrence. Causation. So under Texas criminal law and under, criminal laws in general, there must be causation. So the actus reus plus the mens rea must have produced the harm. It must have caused the result. There are two tests for causation. First is the cause in fact or but for test, meaning that the result would not have occurred but for the conduct of the offender. And there's also legal cause, which is another test. Legal cause refers to the proximate cause. Okay. So legal cause also looks at the zone of danger. Was your actions the proximate cause of the result, regardless of any intervening cause? Let's look at this case that illustrates legal cause. Dan intends to kill Paul. He places a bomb under Paul's car. The bomb explodes, but Paul escapes unharmed. Flying debris hits and kills Peter, an innocent bystander who is standing across the street selling newspapers. Was Dan's conduct the legal cause of Peter's death? What do you think? Yes, right? Because if you look at legal cause, it's like a domino effect. Dan, okay, placed the bomb under Paul's car. Okay, this produced a sequence of events that ultimately resulted in Peter's death. So the bomb exploded. Because of the bomb, it exploded. The car exploded. The flying debris from the car ricocheted and hit and killed Peter. Please watch the video on causation that I uploaded. So it's in the It's in module 2. So this illustrates causation, right? So if you do something, it leads directly to the result. So under causation, law on causation, if there's an intervening cause that breaks a chain of events, then you may not be liable for the result. Here, the red figure breaks the chain of causation, the domino effect. So the offender is not liable for the result. Okay. Let's look at these cases. Dan stabs Paul during a gang fight. The stab wound is minor, and Paul is treated at the emergency hospital room and released. As Paul leaves the hospital, lightning strikes him. Paul dies. Is Dan's act the legal cause of Paul's death? No, right? Because here there's an intervening cause, the lightning, and the lightning is sufficient to break the chain of causation. In fact, the lightning was the force that caused Paul's death. Now let's look at section 6.04 of the Texas Penal Code. It refers to transferred intent. So transferred intent means that the offender wanted to harm one person or property, but because of a change in circumstances, another person or property is harmed. Let's look at this example. Dan shoots Paul. The bullet misses and ricochets and hits Peter. Is Dan liable for Peter's death? The answer here would be yes, because under section 6.04, transferred intent, although Dan sought to harm or injure Paul, and because of a change in circumstances, Peter died, Dan would still be liable. Okay. So let's look at the final element, which is harm. Harm refers to the direct injury to humans or human property. It can either refer to economic loss, okay, or some other loss, such as moral injuries, moral damages. Now, let's look at this case. Your roommate drives a Ferrari. He leaves it behind when he goes on a vacation. You search for his keys and borrow it while he is gone. The day before he arrives in Huntsville, you return it. Are you liable? Was there economic loss? Was there harm from your conduct? Think about it. Now, let's look at victimless crimes. Okay, so sometimes there is no direct injury to persons or property, okay, but it's still considered harmful because the harm is to society in general. Examples would be motor vehicle loss, such as seatbelt and speed limits. There are several excuses and justifications that absolve offenders of criminal liability. The first would be infancy, and the second would be self-defense. Thank you, everyone, for listening to my lecture. I hope you enjoyed it, and please again review chapter 2. If you have any questions, feel free to email me. Thank you.